Could you at least give me the name of say 10 of the people who are giving you the bids?
No, I can't give you the name of 10 people.
Could you at least give me 5 or even 3 people?
No, I can give you one. That's all.
And who is that person?
A gentleman named William Brown.
So you're taking bids that the bids for a painting, which obviously when you're taking a bid, you're going to have to compare a lot of numbers. And you remember taking one bid that day, you remember taking any others?
Well, remember they're all high. You know, too high. So, you know, somebody tells you how much they're going to do it for, you just discount them. But no, I don't remember. I'm an old man with a heart problem.
Do I hear that answer to straight? That last?
I don't know what you use.
Okay, well, thank you.
You're the one with the heart problems, is that correct, sir?
Yes, sir.
So it's kind of hard for you to remember stuff, isn't it?
I don't really remember kids.
Yes, sometimes your mind kind of plays tricks on you when you get old like that.
I'm not that old, Your Honor.
But you're old enough, sometimes that happens to you. So the best thing to do would be just to take down the bids and write these the man.
Yeah.
That way you don't come in here today and tell the jury the names of all the people who gave you bids that day and all the numbers they gave you, right?
Well, yeah, I did not have to do that, though, so that's good to do it.
The whole purpose of the bidding procedure so you can determine who can give you the fairest bid and do the work most economically, right?
Yes, sir.
The only way to compare those is if you haven't done it right, since you can't even tell us the names of 5 of the people who gave you bids that day, right, sir? But if you hadn't done it right in that day, you could have looked at them all and determined who gave you those bids and who gave you the cheapest and best price, right? But you don't have those days.
Didn't have either.
Because you didn't take down any of those bids and right, is that
No,
right?
I tell the big numbers too high, so I just got forgot about it.
No further questions, Your Honor.
Yeah.
Yes.
Although, please rephrase that.
When you lent the car,
Jacket and was also identified. Is that correct? And part of that identification was received from unemployment. Is that correct?
Yeah, I get employment.
Now, correct me if I'm wrong, you just said 3 questions ago that you're working at the Tempo restaurant. Is that correct?
I'm not working. I help my dad out. I testified to help my dad out.
You just said 3 questions ago. You just said that you work at the Tempo restaurant. You're working at the Tempo restaurant. Did you not?
I don't get paid or nothing, you know. I mean, what's the big deal?
So what is correct? So you're saying now the answer you gave 3 questions ago.
Yes, I've been getting the whole time. I help out now and then. I left the box for him. I don't, you know, if I go for a job, I get paid, I get health benefits. I don't get none of that.
Okay, and did you say that you are collecting unemployment? And did you know that to collect unemployment, an individual has to be totally unemployed, meaning he's not
argumented.
any of the money that you're earning from working at the Tempo restaurant.
I didn't earn any money.
Excuse me, so there's no question. Any of that money that you're earning, the money that you're earning from the restaurant, did you let the owner know about that?
There was no money, so I didn't have to let him know about nothing. I mean, I went to buy him a sandwich now and then. I didn't think I had to declare that on my tax. I don't know how you put down roast beef sandwich.
There's no question. Now, you say that Dale Hall came to pick you up around 11:15, is that correct?
A little bit earlier about that, but
And you went to the van that morning, is that correct?
yep.
And you went to the van, were the items that you just testified to being in there, were they in there?
No, the van was pretty empty. I mean, there was some trash, probably a couple of beer bottles, but you know.
So you got in the van and did all that afternoon. It didn't seem peculiar that there was a gun, there was a television, there was an amplifier, things that weren't yours in the back of your van. Didn't seem strange that they were there.
No, well, I figured that's why he wanted to borrow the van, because he said he had to run the errands. I figured he was moving his stuff. I didn't go through and see what everything was.
Now you said that you were also in the little general store, and all of a sudden you came running in. Now, would a person with a guilty conscience run?
Objection, Your Honor. False speculation.
Please answer the question.
I don't really know. know, I can tell you somebody without a guilty conscience to run, because I sure did.
Now, earlier today, Richard Miller, person who's not testified that he identified you as one of the people who were at his house, taking items from his house. Is Richard Miller telling the truth, or is Richard Miller lying?
He says he saw me. He's got to be lying or mistaken, one of the two.
What reason does Richard Miller have to lie?
I have no idea why I do it. Maybe he thinks I will. Maybe somebody who looks like me. I don't know.
You're going to get along with the person who you said you now hate more than anything, as your good friend before. Earlier, he testified that the same person who was with him at the general store running with him was also the same person who burglarized the home. Was Dale lying?
He had to be, because I wasn't with him anyway, so.
Does it seem strange to you that Richard Miller's lying, Dale Allen's lying, all these people are lying just to get you? Does it seem strange to you?
I figured there's just two of them. One, I figured probably not as mistaken, and Dale sure has reason to, man, after borrowing my van to do this stuff with. You don't do that, friend.
You just testified that you are testifying here under the grant of immunity, isn't that correct?
Yes.
And the state has offered you that immunity to testify here.
Yes, they have.
And you gave a definition. Could you just explain that definition of immunity to me, please?
It means you don't go to jail.
And is that it?
I guess, is that what you're asking me?
I'm asking you for your definition of immunity.
I would say it means, you don't go to jail. Yeah, I won't go to jail.
Can I have one moment, Your Honor? Your Honor, let me go sidebar, please. Your Honor, at this time, due to the witness's definition of why she's here, she doesn't seem to understand why she's here under the immunity. She's just saying she doesn't have to lie. There's obviously a lot more to immunity than that, and she doesn't seem to understand that. And I would like to have this witness declared incompetent.
Your Honor,
You know what?
Your Honor, he hasn't asked any questions asking what the terms and conditions of the immunity
I asked her for
are.
her definition of immunity, and it's clear that she doesn't understand the definition of immunity. She just said she doesn't have to lie.
No, I said I don't
She
go to
didn't even say
jail.
that.
Excuse me.
Jail.
Right. I'll continue, Your Honor.
He understands the nature and obligations of the oath. That's what confidence is. Obviously, the oath is 6 years old. Seems to me, I don't
Okay, all right.
understand what would make her incompetent.
It was a stretch, Your Honor.
Your Honor,
I'll continue. It was a stretch.
while we're sidebar anyway, if the defense would like to bring up the immunity, we would ask that they also be required to bring up the terms and conditions of the immunity for having to speak the truth, since that is a relevant part of it.
Thank you, Your Honor. Now, you testified that you've known both defendants, Mr. Howell, and you've known Mr. Howell and you've known the defendant, Mr. Peters. Isn't that correct?
Yes.
And in fact, you've known Mr. Howell for many years,
Yes, I have.
and you've also known Mr. Peters for many years. Isn't that correct?
Yes.
And you have known Mr. Peters for approximately 6 years,
Yes.
and you lived with him for 3 years.
Exactly.
During that time, it's safe to say that while you lived with him, you had a very close relationship with Mr. Peters.
Yes, I love him.
And you said earlier that you were boyfriend and girlfriend. You loved him, your boyfriend and girlfriend.
Yeah. Yes, that's correct.
Now, before the incident of October 17th, you and Mr. Peters had stopped being boyfriend and girlfriend. Isn't that correct?
Yes.
And you had stopped seeing him so much that in the month of September and in the month of October, you barely saw him. Isn't that correct?
Yeah, we just stayed off and on now.
And the two of you were having serious fights and serious arguments, and that's what led to your breakup. Isn't that correct?
Yes, we were having some arguments.
Matter of fact, some of those arguments were pretty violent, were they not?
Yeah, we had bad words between us, you know, yelling and stuff.
So it's safe to say that while you guys were yelling and having these violent arguments, you didn't like Mr. Peters too much at those times, did you?
Well, I loved him. I wanted to marry him. He didn't want to marry, you know, we weren't sure what we were going to do, and we fought, and, you know, I love him.
Going down to October 17th.
Yes.
On that date, you and the defendant, Mr. Peters, went out, isn't that correct?
Yes, we did.
You went to the Newtown area and had a couple of drinks, isn't that correct?
Yes.
And then you went over to Mr. Peters' house, isn't that correct?
Yes, I did.
And you said Mr. Peters then received a telephone call,
Yes.
and you never heard anything, you never heard that conversation, isn't that correct? You just heard Mr. Peters' end.
Yes, I heard Mr. Peters tell me.
You did
He
not hear
told
the
me.
other party on the other side.
No.
So anyone could have been on that line and you have no idea what the conversation was about.
Well, anyone, Peter told me what it was about, but anyone
you did not
could.
hear.
But I didn't hear, no, I didn't. I
So
wasn't
you
on
did
the
not
phone.
know, isn't that correct?
Yeah, I did not know, I did not hear,
Thank
no.
you.
But I know, I mean,
Thank you. Now, after the phone call, Mr. Howell arrived, isn't that correct?
yes,
And Mr. Peters and Mr. Howell had a conversation, isn't that correct?
yes, they did.
And then Mr. Howell inquired about buying some cocaine, isn't that correct?
Well, they talked about it, yes, about them selling it.
And after the conversation, you went to get the cocaine with Mr. Howell and not Mr. Peters, isn't that correct?
Yes, because Fred told me to go get it. He would wait there.
Excuse me, I just asked if you and Mr. Howell went to get the cocaine, isn't that correct?
Oh, yes.
Objection, Your Honor. Badgering. She's allowed to explain her answer.
The question was? Now after leaving to get the cocaine, you and Mr. Howell went to your house and you had a few beers, isn't that correct?
I didn't, no, William had a beer.
Well, you had some beers earlier that day, isn't that correct?
I had like 1.5 at the, like an hour and a half earlier, yeah.
And then you took the cocaine once you got over to your residence. You took the cocaine, you took the, strike that, Your Honor. Thank you. And then once you got to your residence, you took the cocaine from your dresser drawer and you took that cocaine and placed it within your brassiere, isn't that correct?
Yes,
Then you went and picked up some more beer, isn't that correct?
yeah, Fred, yeah, they wanted some beer there.
And then you went to Mr. Peters' home and cut up the cocaine, isn't that what you did?
I didn't cut up any cocaine. Fred did.
Do you remember being asked a question at your earlier deposition?
May we please have the page number in this statement?
Page 54. Do you remember making a statement when asked a question, well, what were you going to do that night? Go out with Fred. What about William? That was William's business. I was to go out with Fred. William wasn't involved in our date. Do you remember making that statement?
Yes,
That it was William's business that night?
yes.
Thank you. No more.
Objection, Your Honor. That statement is taken completely out of context.
Counsel, you want to read the last, next question?
Didn't you say it was William's business? Well, what William was going to do afterwards was his own business. I had no idea what he had planned for himself for the evening.
Read your back.
Yes, Your Honor, briefly, if I may. Say it all, Your Honor.
Certain lady, I'm assuming that's
Did anyone tell you what to do with the cocaine after you returned?
Objection, Your Honor.
Yes,
And who told you what to do?
Fred.
May it please the court, counsel, ladies and gentlemen of the jury. My name is Steve Scheinfeld, and along with my partner, Jay Kreutzer, we represent the accused here, Mr. John Burns. Ladies and gentlemen, the purpose of this opening statement is to give you what I want you to visualize as kind of a roadmap of the things that will be coming along during this procedure. I want you to kind of get a sketch in your mind of what the state will present and then what Mr. Kreutzer and I will also be presenting. After these opening statements, the prosecutor will begin the proceedings by bringing up some witnesses. There will be some direct testimony. And after each one of those witnesses has completed their testimony, Mr. Kreutzer and I will have the opportunity to cross-examine each of them. I want each of you to remember that the cross-examination testimony is just as important as the direct testimony each of them will bring out with their witnesses. Listen to all the witnesses equally, and then when everything is done, determine for yourself the credibility and the truthfulness of each one of these witnesses. Once the state has completed its case, Mr. Kreutzer and I will be calling our own witnesses to represent Mr. John Burns' case. All we ask is that you keep an open mind after all the evidence has been completed during this procedure. And when all of this is done, weigh all the evidence carefully, ours as well as theirs. The issues before you in this case are whether or not John Burns committed attempted robbery and murder. And to help you come to a conclusion on those issues, there's one thing that you have to remember. Mr. Burns possesses something more valuable than anything in this courtroom right now. More valuable than money, more valuable than jewelry, more valuable than any material effect. He possesses the presumption of innocence. John Burns has pled guilty, and with that plea, the law presumes him to be innocent. That is a command of the law that you as jurists must uphold. Now, not just for Mr. Burns, but also for yourselves. It's a key presumption in this democracy, and it protects you, it protects me, it protects the state, it protects everyone in this courtroom. It is up to the state, Mr. Morey and Mr. Baxter, to prove to you that Mr. Burns is guilty beyond and to the exclusion of any reasonable doubt. And if they fail to do so, it is your duty to come up with the verdict of not guilty. They must prove, beyond all common reason and all common sense, after careful consideration of all the evidence, that Mr. Burns is guilty of a crime. Now remember, we don't have to prove his innocence, they have to prove his guilt. Now, ladies and gentlemen of the jury, you're here because the state is saying that Mr. Burns committed an armed robbery that led to the death of Teresa Carletti. You will hear from the prosecution witness, Mr. James Carletti, the husband of Teresa. Now, his story is a tragic one because you will hear the anguish of this man as he watched and held his wife as she died in his arms. By a bullet he shot from his very own gun. His store, the IGA Market, was the family business, and the Carlettis worked there together. The market had been robbed before, and Mr. Carletti felt it was important for him to protect himself, so he went out and bought a gun. And when he went out and bought a gun for protection. And when a man walked into the store that day, a man who Mr. Carletti had seen before and had caused problems in the store, Mr. Carletti knew that this would be the first and one time he would need to use that gun. And when the man demanded money, Mr. Carletti did what he felt he had to do. He had to protect his store, he had to protect his wife, and he had to protect the valuables that he felt were rightfully his. Unfortunately, you will hear from the prosecution's witness, Mr. Carletti, that the gun that he used to protect himself was also the same gun he used that ended in the death of his wife. The one thing you must remember, and you will not hear from Mr. Carletti, is an identification of Mr. Burns on the scene, because Mr. Carletti never identified Mr. Burns at the scene of the crime. Next, you will hear the testimony from another one of the state's witnesses, Mr. Lauren Jones, the man who went to the IGA Market with the sole intention of stealing money. Mr. Jones went to the market because he thought it would be an easy score. Scare the old man, wave the gun around, and get out of there. State's witness Jones will tell you how he needed the money because he was out of a job and his unemployment had run out. He will tell you how he hitchhiked to the IGA Market from New City down to Nita City. And during that hitchhiking trip, he took many rides with many people he did not know, ending up with the final ride with a person he did not know who dropped him off in front of the IGA Market. Once in front of the market, he will tell you He went into the market, but he didn't intend to hurt anyone. But that's exactly what Lauren Jones, did. When he alone, after planning, went into the IGA market to steal some money, and in the course of that robbery, Mrs. Carlotti was murdered. Witness Jones will then try and explain to you how his story to the police changed 3 days later, implicating John Burns as a participant in the robbery. Mr. Kreutzer and I will explain to you how and why Mr. Jones's testimony all of a sudden changed from 3 hours after the crime. 3 days later, his story changed. Now, after the state's completed its case, Mr. Kreutzer and I will then have the opportunity to call witnesses of our own.
1 minute, counsel.
First, we will call Mary Burns, John Burns' wife for 8 years. She will tell you about their life together, their 8 years of marriage, and she will tell you about the day's events. She will tell you how Mr. Burns was home that day, working around the home, and how she saw him there the whole time. She will then tell you how she prepared dinner later on that afternoon while Mr. Jones and Mr. Jones's friend, Larry Roberts, were watching TV and having a few beers to relax. Next, we will call Mr. Roberts, who will tell you pretty much the same story. He'll tell you how he arrived that day at the Burns home just to relax with his friend, have a few beers, and watch the Las Vegas Invitational on TV. And finally, you'll hear from the prosecution witness, you'll hear maybe from Mr. Burns. It is important for all of you to remember that Mr. Burns does not have to take the stand. If the state does not show anything to prove John Burns is guilty, he will not take the stand. But if he does, he will tell his story. And his story will be how this is a man who was in the Army. And when he left the Army, he met his wife, he got married, he started a family. He worked to provide for that family, and he also collected unemployment. He worked to provide for his family until there were no more jobs left, and then he had to collect unemployment. And on this day, on the day Mrs. Carlotti got killed, Mr. Burns would tell you how he was home the entire day, except for 90 minutes in the morning when he went grocery shopping. He had never, till this day, been to the IGA market. Finally, he will tell you that Larry Roberts came over that afternoon, they relaxed for a few hours and watched some television. And then Mr. Roberts left. Mr. Burns had dinner with his wife and his family, and later that evening, they prepared for the following morning where Mr. Burns and his kids were going to have a nice breakfast in bed with Mrs. Burns because it was Mother's Day. The evidence, ladies and gentlemen, will show you that Mr. Burns has nothing to do with the robbery at the IGA market and the subsequent death of Mrs. Carlotti. Her death is a tragedy, and I ask you that you don't compound that tragedy by putting an innocent man in jail. We selected you members of the jury because you were fair and honest people, and we feel you will come back with a fair and honest verdict of not guilty. Thank you. Counsel, ladies and gentlemen of the jury, I would like to thank you right now, as stated, for your attention during this past week. I would also like to thank you for being here in the jury, but I know that for all of you, this really wasn't a choice of yours. It was a duty brought to you by the state. I just want you to know that I think that in itself is self-rewarding, because that's the greatest duty you can have as a citizen of this country. This will be the last time that you hear from me or Mr. Kreutzer in this proceeding. Then the work is going to begin, and that's going to be left up to you. It's going to be your duty to come up with a decision here. This will be the last time you hear from me, because after I'm done, the state will have an opportunity to close out this proceeding. And it's just that they do, because it's the state that has the burden of proof here to prove guilt beyond a reasonable doubt. I do not have that duty. Now, Mr. Morey and Mr. Baxter must prove beyond a reasonable doubt that John Burns is guilty of a crime. If they don't, it's your duty to find him not guilty. I would like to read to you exactly what that doubt is. A reasonable doubt is a real doubt based upon reason and common sense. And after careful and impartial consideration of all the evidence in this case, proof beyond a reasonable doubt is therefore proof of such convincing character that you will be willing to rely and act upon it without hesitation. If the state proved that, you would have no problem, and you could say that he's guilty. If the state has not proven that, you have the same duty to say so. Ladies and gentlemen, there is reasonable doubt here in this case. First, let's look at the robbery. For the state to sustain that charge, the prosecutor must prove that John Burns or someone he was working with took something, that the thing had value, that it was taken from another person, and that it was taken under the omen of threat or intimidation. You heard the witnesses, ladies and gentlemen of the jury. You heard Mr. Carletti Mr. Carletti was working in his store that night with his wife when Lauren Jones came walking in. Lauren Jones demanded money. He pointed his gun at Mr. Carletti. Mr. Carletti, in fear for his life and to protect his wife and what he felt was rightfully his, drew a gun and fired at Lauren Jones, tragically killing his own wife. Mr. Carletti never positively identified or even said that John Burns was at the scene of the crime. Mr. Carletti had no idea if John Burns was involved in this robbery. You then heard from Detective Hellman. Detective Hellman would have you believe that because a fingerprint was found on a gun, that John Burns was the person involved in this robbery also. You heard from Mary Burns that the gun was stolen. She just forgot to report it stolen. They had many guns in their homes. She's a wife. She's a mother. She takes care of 3 children. She didn't report the gun stolen. One fingerprint on a gun does not prove anything. You then heard from the state's star witness, Lauren Jones. Mr. Jones is the one person in this whole proceeding who has more to gain than anybody by having John Burns go to jail. Lauren Jones, a few hours after he was arrested, told the police what happened. He planned this robbery. He hitchhiked from New City to Nita City, getting rides from many people, none of them whom he knew. The last person dropped him off in front of the store. Lauren Jones and Lauren Jones alone walked into the store and committed the robbery. Lauren Jones in that first statement never said anything about John Burns. Lo and behold, a few days later, Lauren Jones' story changes, and Lauren Jones is now implicating John Burns because Lauren Jones realizes that if John Burns goes to jail, I may see the light of day again. I may not have to spend the rest of my life in jail. Then you heard from John Burns himself. John Burns, under oath, on this witness stand, testified that he was home, say, for 90 minutes in the morning when he went to the grocer's. His wife testified to the same thing under oath, and his friend, Larry Roberts, testified that when he got there that afternoon, John Burns was there. He had called John Burns a little bit earlier and spoke to him on the telephone. Now, the state said that Mary Burns assumed her husband was home when she went downstairs to do the laundry. Mary Burns didn't say that on the stand. She didn't say she assumed her husband was home. Mary Burns said that when she was down there, through her window, downstairs in the basement, she could see that the car never left their home. That wasn't an assumption on her part. She knew that for fact. Now, for the murder aspect. Felony murder is strange in a way. That means that someone is committing a felony and someone dies. And the state looks at it as if someone is committing something that evil and someone dies, they should pay the price. Once again, ladies and gentlemen of the jury, you can go over the testimony yourselves. We don't have to go over it all again. John Carletti never identified John Burns. Detective Hellman never identified John Burns. John Burns, Mary Burns, and Larry Roberts all told you under oath on the stand where he was at the time of the murder. And of course, there was Lauren Jones' statement once again. But Lauren Jones is the man who I just said has more to gain than anything by having John Burns go to jail. 6 witnesses, 5 of them with no identification of John Burns as the person who committed this robbery. 1 witness who had everything to gain. That seems to be weighing to a lot of reasonable doubt, ladies and gentlemen. I've spoken a lot this week, and I'd like to leave you with just a few thoughts. One is that you've worked hard this whole week. You've listened to everything, but the real work begins now. You must come up with a decision. It's going to be a decision that you remember for the rest of your lives. It's also going to be a decision that John Burns remembers for the rest of his life. This week you've been involved in a very tragic story